Hi, this is Vincent.
Hello, Vincent. This is the Slime Beast. Since I haven't been able to get in touch with you regarding any of the trademark stuff, I'm gonna make this video to ask some questions and make a few statements regarding your answer to people's concerns. Since I know you've seen my videos, I at least know my messages will get through this way. I just want to start out saying that I have nothing against you personally. I'm sure you're a great person. I just have some concerns that I'm going to be raising in this video.
I think people are up in arms about it, and I think it's mostly because of the whole Fine Brothers fiasco.
While I would believe that that is part of the reason people are on high alert about trademarks, it mostly, I think, for most people comes down to the fact that you're trademarking a word that is widely used and that you didn't create.
And I get why the YouTube guy, the writer, um, did that too. Maybe he was concerned as well, and he didn't know the whole story.
Since I'm the person being talked about, I can pretty much answer this directly. My concern is that I have every right to use the word creepypasta in a title of a book. An ebook, a print book, anywhere I want to use it because it's not anyone's property. So if you trademark the word creepypasta and you yourself are making a book and a comic book titled Creepypasta and you want to protect that, that is not your right. That is my concern.
He didn't email me beforehand.
I contacted you on Twitter, and I contacted you on Skype. I contacted you on Twitter multiple times, and I still have received no response. I contacted you on Skype multiple times and have received no response. Granted, if I had emailed you, maybe you check your email more often than anything else. But, I mean, you've posted on Twitter after I contacted you, so you did see the messages and didn't reply. There's also the fact that I couldn't email you before I started researching the Creepypasta trademark, because I didn't know you owned it until I researched it. And I couldn't email you before I made my first video because I didn't know that you were the same person who had trademarked it. It's not possible for me to contact you before I find out who you are.
I respect him for his work and his contributions to the creepypasta community, and I definitely would have given him the whole story.
I'm putting one of 3 tweets I sent to Vincent up on the screen, all 3 unanswered. If I only had to ask to get the information, then why, when I asked, was I not given the information?
I've owned the trademark for a while, and if you've noticed, there's been absolutely no changes to the creepypasta community.
While you have owned the Creepypasta trademark for about 1 year, there's a lot of time in the future for things to happen. So the fact that nothing has happened yet isn't really an indicator that nothing will ever happen. Especially if someone else puts out a book or a comic book titled Creepypasta that's in direct competition with yours. The comic book and the book or whatever titled Creepypasta, you haven't put that out yet. After your book comes out, are other people going to be able to title their book or their comic book Creepypasta? Or are you going to have a problem with that because it's, causing confusion with your brand? So the fact that there hasn't been any problem yet really doesn't mean anything.
This isn't far from a Fine Brothers situation. I am not, nor do I have the ability to even siphon money from people.
While I agree that it's not possible for you to siphon money from YouTubers, I think the concern people have is that it's well within your right to shut down or have removed products that use the term creepypasta in the title. If somebody puts out a book called Creepypasta, 10 Tales to Astonish, you have the right to tell Amazon to remove that book because you own the trademark to the word creepypasta for books. Nobody is alleging that you're going to siphon money from YouTubers. The concern is legitimate in what you actually have the right to do.
But these guys had apparently trademarked reaction videos, and they had a different type of trademark that gave them the right to the formula of reaction videos or something.
While the Fine Brothers did claim that they owned the formula for React videos and that everyone was ripping them off and stealing their formula, that is not what they trademarked. They trademarked the word React. So the word React was trademarked by the Fine Brothers in the exact same way that the word creepypasta is now trademarked. We're not talking about the Fine Brothers trademarking a process because you do not trademark processes.
What you guys need to understand is my literary trademark for creepypasta, it only gives me the right to the word, to put the word on a book cover.
Your trademark actually gives you the exclusive right to put creepypasta in your title. That means that, it's not a matter of you now have the right, like everyone else, to put creepypasta in your title. Everybody already had that right. The right that you have now is to be the only person allowed to put creepypasta in their title. And, you can decide to let other people do it or not. That's, a separate thing. But what you registered for was a standard character mark. And a standard character mark basically means you own the actual word exclusively, and no one else can use that word in that format. So in other words, strictly legally speaking, nobody else but you is allowed to use the word creepypasta when it comes to books in the horror genre. Now, what you decide to do with that power is completely different. That's kind of irrelevant to the fact that by registering for the standard character mark, you now have the exclusive legal right to use it. Only you can use it as far as the law is concerned.
What it does not give me is the rights to any stories. It doesn't give me the rights to your favorite characters.
This is true, and I think that this fact is mentioned maybe 4 or 5 times across this video, that you don't own stories or characters, but I would point out that nobody has said that you did.
A lot of people are saying that you don't trademark something unless you want to enforce it.
That's a fair thing for people to say, because that is literally the only reason that trademark law exists. There's no other reason to trademark something other than to enforce your trademark, and I know that you give reasons later in the video, but I'll be addressing those. Further, I think it's interesting that in the Just Ask post that you made a while back about your copyright, you did mention wanting to protect your brand. When nobody was looking, when nobody had heard about the fact that you had trademarked this, in a discussion where you were asking information about your trademark, you did expressly state that you wanted to protect your brand, indicating that the word creepypasta, you intended to make that your property, your brand. That's how it looks from my perspective. I absolutely cannot know exactly what is in your head. This would appear to the casual viewer, like myself, who's maybe a bit skeptical about everything they hear, it would appear as if you now are saying that you trademarked it for different reasons, basically because you know that people are mad about it. And, I'm not saying that is the case. I'm saying that's how it looks, and by all means, I welcome any explanation, totally disavowing or totally disproving what I'm saying.
There's very, very limited things that I can use it on.
While I agree that you are limited to using the trademark against people who use creepypasta in the field of horror books, which would be ebooks, print books, etc., saying that it's limited doesn't really change the fact that, you do have the power to use it against people. I'm not exactly sure what difference it makes that that it's limited.
I did it specifically for 2 reasons. 2 main reasons. And the first one is, I'll explain to you, is that I'm sick of plagiarism.
The problem here is that nothing about registering a trademark helps you fight plagiarism. This seems like a non sequitur. I don't exactly know how you're saying that owning the creepypasta trademark will stop plagiarism. I'm going to go through, in the interest of keeping this video short, I'm going to sort of leave it there as to, just you saying that you're fighting plagiarism. There's more in the video if anybody wants to watch it. Link is in the description about how he intends to fight plagiarism. It doesn't make any sense. All you have the right to do right now is remove the ability for others to use the word creepypasta in their title. To use the word creepypasta in the form of books or, ebooks, etc. You don't have any new ability to fight plagiarism by registering the trademark. The two things are completely unrelated. Registering the trademark will not allow you to now have additional powers in stopping plagiarists. You can take down a book. If somebody plagiarizes a bunch of stories and they call their book Creepypasta, then you can take the book down based on the fact that you now have the exclusive right to name a book Creepypasta. You can tell Amazon, you can tell, any site or any company, don't sell that book because I own the title. However, if somebody plagiarizes a bunch of stories and they don't name their book Creepypasta, there's nothing you can do about it with the trademark. If somebody plagiarizes every creepypasta ever written and puts them in a massive book and titles the book Internet Horror, how did registering the trademark for creepypasta help you stop that person from plagiarizing those stories? Registering the trademark is completely unrelated to fighting plagiarism. There is no way, absolutely no way those two ideas connect. It just makes absolutely no sense. And, this is the part where I get kind of a little frustrated and perhaps even just bordering on livid, because this explanation, I registered the trademark to fight plagiarism, makes absolutely zero sense. And you only need to spend a split second thinking about it to realize that it doesn't relate in any way. There is no way that you're going to stop plagiarism by registering a word trademark. The guy that you cite in your video who is taking people's stories and putting them in a book, all he would have to do is change his book's title, and you have nothing to do against him with your trademark. It doesn't make any sense. And, I'm pretty comfortable in my assumption, and again, this is just my assumption and my opinion, but I'm pretty comfortable in my opinion that you did not register this trademark in order to fight plagiarism. Again, going back to the fact that it makes absolutely zero sense. Further, if you want to fight plagiarism on Amazon, etc., they have copyright for that. Stories are copyrighted. The minute you create a story and put it out there, you have an automatic copyright to it. And I have personally, this is first-hand perspective, I have personally had books removed from Amazon because they had my stories in them. And the way I did that was I filed a copyright complaint. I didn't need a trademark. I didn't need to trademark the word creepypasta. I didn't need to trademark anything. All I had to do was click on the copyright notice on Amazon, file a copyright form, and Amazon immediately took the book down. They would immediately take down any novel, or any, I guess you would call them an anthology, that had my work in it. I've been doing what you claim to be doing. I've been removing books from Amazon, specifically that exact website, for years. And I never needed a trademark. It would never enter my mind, in any regard, to trademark something in order to do that, because I already have the copyright for the story. Any author whose work is in one of these books can file a copyright notice. And granted, I look on Amazon maybe every 6 months or so. So I'm sure that there are some up now that I've missed, but I'm going to get to them. And I'm going to have the plagiarists removed without filing a trademark. Because the trademark registration has absolutely nothing to do with stopping plagiarism in any regard. Furthermore, back in the Just Answer post, back when nobody was looking, You stated that the plan was to publish a comic book and a Goosebump-style book series under the trademark of Creepypasta. There's no mention of any of your altruistic goals in your first post about, your first outing explaining why you trademarked the title. Everything in the first explanation you made about why you registered the trademark, everything says it's to protect your brand and to publish your own book series with the title. If this was your intention from the start, why is it not said in anything up until this point that this is what you wanted to do? If from the start, if you registered the trademark to altruistically help people, why did you not post anywhere, "Hey everybody, I just wanted to let everyone know I'm trademarking Creepypasta so that we all can use it, and so we can fight plagiarism"? Instead, everything you've said about it has been for personal use. And fighting plagiarism and these, positive goals to help everybody are only coming up now in answer to people finding out that you had trademarked the title. It appears on the surface as if you're making this up. I'm just saying how it appears. I don't, there may be some grand explanation, as to why you originally said it was only for yourself, and now that, people are mad about it, you're saying that it's for everybody. Maybe there's some big explanation for that, I welcome that explanation. I'm not going to get it right now when you're not replying to anything I send you, but,
I'm thinking about enforcing it, but if people are uncomfortable with me removing plagiarists like this off of Amazon, then fine.
I feel like the obvious question at this point would be, if you filed the trademark to stop plagiarists, and you cite in your video books on Amazon that are plagiarizing things, why have you not used your trademark in the year you've had it to remove those plagiarists? Have you actually used it to remove any plagiarists from these websites? If the answer is no, then that obviously is not why you registered the trademark. If you are asking people, in this video you say, "I'm not really sure if I'm going to use the trademark to go after plagiarists, let me know what you guys think, do you feel okay with that?" If you had actually registered the trademark to go after plagiarists, you would be doing that. It wouldn't be a matter of, "I'm thinking about doing it, let me know what you think, guys." You would have asked people what they thought and whether you should do it before registering the trademark. You have it now. You've had the trademark for a year. How many plagiarists have you removed from Amazon? From any website? You bring up their books and their pages, with the book for sale in your video. Did you report those people? Did you file against them to get their books removed? Because they are plagiarists. If you did the trademark registration to fight plagiarists, how many plagiarists have you fought in the past year?
I want other content creators to be successful. That's why I did this.
How does registering for the exclusive right to use the word creepypasta help others be successful? You clearly stated that your reason for registering the trademark was to protect your brand, the word creepypasta, to make it yours and to protect it from unauthorized use. How does that help anyone be successful? If anything, it's going to stop other people from using the word creepypasta in their titles, which will mean that they do not get as much of a search rank. They don't show up when people search the word creepypasta as well as they would if they had it in the title. This actually hurts the success of others, theoretically. And even if you don't want to enforce the trademark, people will still be shy about, doing it in case you decide to at a future date.
I've made no secret about this trademark. If you check out right here,
I can see here that you say I own the TM. It doesn't say what you own the trademark for. You may have been saying that you own the trademark for the word creepypasta on January of this year, but, again, it doesn't say that here. It's not like you publicly stated your goals, your mission, and the fact that you were planning to trademark creepypasta. All that happened was at some point, you randomly in some, long forgotten Twitter conversation said the words, I own the TM. This is not the same as being public about what you were doing or what you were planning. It's also very interesting that you're not saying, I trademarked this so that we all can use it, and so we can be protected and we can stop plagiarists. What you're saying in this post is, I'm releasing a bunch of books and I own the trademark. It's not, it's basically saying, I'm releasing something and I trademarked the title. It's not anything positive about anything other than it's just stating the fact that you bought the rights to something.
and again, I want to reiterate that I do not own these characters. Nobody does.
People do actually own their characters that they create. Again, copyright law, something is copyrighted when you create it. To say that nobody owns anything in Creepypasta, like the characters, is so woefully inaccurate that I don't even know how to properly respond to it. What I will say is this. Yes, people do own their characters. And nobody owns the word creepypasta.
I actually spoke with the admin, the guy that runs creepypasta.com. I had a conversation with him regarding the trademark, and he has said that he trusts me with it.
To put it bluntly, I don't actually care if other people trust you with it. Presumably people you've spoken to before, people who are fans of yours, people who are friends of yours, people who are fans of your work, or people who benefit from your work. I don't really find any merit in, trusting the entire thing because some of those people trust you with it. You said in the beginning that you were doing this to protect your brand, and you said now that you're using it to stop plagiarism, with which it doesn't relate to, and that makes no sense. So, I am more interested in removing all bias, not looking at this as a fan, not looking at this as a friend, not looking at this as a co-creator in the world of creepypasta. I just want to look at the very basic facts of the matter, and none of this is lining up.
I've had a conversation with a lot of writers, creepypasta writers, and they said that they trust me with the trademark. YouTubers, that they trust me with the trademark.
I know about this. I was informed by someone who was contacted that basically Vincent and Mr. Creepypasta have been sort of doing and I'm going to use this term, but don't hold it against me, have been sort of doing damage control, that after the revelation was made, that Vincent had trademarked Creepypasta, that after that was revealed, Vincent and Mr. Creepypasta went on a mailing campaign, of contacting a lot of people within the Creepypasta community. And, I've been told this firsthand by one of the people who was contacted, who's a very large player in the Creepypasta community. And, that they were going around explaining the whole situation to everybody. So, saying that, you contacted people about this and they all trust you with it, yes, I'm sure that what happened was you emailed them after it was revealed that the trademark had gone through. You emailed them afterward and said, here's the real story of why I did it. You and Mr. Creepypasta. And, they probably all said, oh, well, that sounds reasonable. That sounds logical. I have no doubt that happened. But the fact that you, as I said, did the damage control and went around and smoothed things over, doesn't really give me any solace. That just says to me that you guys successfully convinced people that it was to fight plagiarism, which again makes absolutely no sense whatsoever.
Slender Man has been trademarked and not by the original content creator.
This is actually not the case. The original content creator did own the rights to Slenderman. He sold them to another company. So that's not exactly true.
This company has actually prevented these projects from going through, like a video game, I believe.
I get what you're trying to go for here. You're trying to say that a company came in and trademarked Slenderman out from under the creator, and now nobody can use it. But, and that you are trademarking Creepypasta so that another company doesn't come in and trademark Creepypasta out from under it. But there's two reasons this fails. One reason this fails as an explanation is that you're only now looking up the Slenderman ownership. So that means that this wasn't something that informed your trademark. Also, as I said, Victor Surge sold the trademark rights, sold the copyright rights to this company. So this isn't a company that came in and trademarked it out from under him.
But I'll tell you the second reason why I trademarked this.
Holy shit, we're only to the second reason. I'm so sorry, everybody.
I had some inside information that there was movie studios and media companies that were interested in Creepypasta.
I don't believe you did. Unless the movie studios personally called you, or you knew people working at all of the movie studios that were about to trademark Creepypasta, I don't think you actually had insider information about what all these companies were about to do. The reason that this doesn't ring true for me is that, you said in your Just Answer post, again, when nobody was looking and we didn't know that you had done this yet, you said in the post that you were just learning that media companies were also trying to get the trademark. You posted that you were learning that other companies wanted it after you filed the trademark. So this is, I hate to say it, but this is one of those cases where the old phrase comes in. Was it a lie then, or is it a lie now? And the question then would be, why would the lie be to the random person on justanswer.com? Why would that be the one that isn't true? I get what you're going for here is that, you knew that somebody was going to trademark Creepypasta. That movie companies were going to trademark Creepypasta. And so you moved to do it first so that you protected it for everybody else. I don't believe that. Namely because, as I said, you expressly stated in your own words that you did not know that media companies were about to do this. And, there's also the fact that you only trademarked it for horror in books. You only trademarked it in the area that you were going to be working in and protecting your brand, as you called it. You did not trademark it in the field of motion picture, audio, video. If you were trying to stop movie companies or entertainment companies from trademarking it in the field of movies, audio, television, etc., you would have trademarked it in the field of movies, audio, television, etc. to block their trademark. Instead, you trademarked it only in the area of horror books, which just so happens to be where you were going to be using the title. I hate to say it, and as I said in the beginning of this video, I'm sure you're a great guy. I feel like your back is against the wall, and you're having to explain, things away. But I also feel like this explanation is not true.
The presiding attorney who looks at all applications saw that I had already applied. and he felt that it created a conflict and confusion within the branding.
I do like the fact that you said branding as if, like, pff, who cares about that? When that is exactly what you were talking about in the beginning, wanting to protect your branding. Acting like you've never heard of it before, acting like you don't care about it when that is specifically what you said you cared about in the beginning. I just like that little affectation. But, the fact is that when you applied for the term, they also should have rejected your claim. I mean, it's all well and good to say it's a good thing that they rejected the claim of this other person, that it's in suspension. And it's good for us that that's in suspension. But also, yours should be in suspension too. Yours also should have been disallowed. So, yeah, we can cheer about that one other person, having their trademark suspended, which I have to look into. But, that doesn't exclude the fact that you also should not have the trademark for something that you didn't create and you don't own and that is publicly used.
I've made a very tiny name in this community.
Don't be so hard on yourself. Your name is essentially synonymous with Mr. Creepypasta, who is the #1 most recognizable name in all of the Creepypasta community. There are thousands upon thousands of readings of your work out there. You basically are a Creepypasta celebrity. So I wouldn't, go the route of saying, I'm just a small-time creator with a very small name in the business. You're basically a very public figure that, has built a very big reputation on your work. And, to the point where you're actually friendly with Mr. Creepypasta and you know each other and work together all the time, and he contacts people on your behalf to tell them not to worry about you with the trademark. So, let's not do the thing where it's like, I'm just a small name, and, why is everybody, worried about me? Let's not do that.
And I haven't really been hiding it, but, there is some sensitive information available by looking it up through the USPTO, and I didn't want to be bothered personally.
I have to take issue with this. It is not sensitive information. By U.S. law, we have to be able to find who has trademarked something. That is the law, that we be able to see the name of someone, the company that has trademarked information, that has copyrighted something, that has patented something. So it is not sensitive information to find out who did something. Secondly, let's address the real meaning of this statement that you've just made. You just basically said that you did not want to keep it a secret, and you're annoyed that people found out you were doing it. So you didn't want to keep it a secret, and you didn't want anyone to find out. Do you see how not wanting people to find out and keeping it a secret are the same thing? I mean, you can't have both. You can't say, I wasn't keeping it a secret, and then say, how did they find out my secret? I mean, granted, you said I own the TM once. But, that's really neither here nor there, because it wasn't expressly stated what the hell you were talking about. It's a crazy thing, and the sad part of this is that you flagged my videos about this situation, both the videos. You flagged them for privacy rights violations over your publicly available trademark records with the U.S. government. This is not something that you do, buddy. If this had been decided that I was violating your privacy in my videos, I could have lost my fucking channels. I could have been shut down. At the very least, the videos I made, giving my opinion about the situation, could have been deleted from YouTube. Based on you filing fake privacy rights alerts. Based on you looking at a video that shows public U.S. government records of who owns a trademark and deciding to flag that as private information, which it is not by any stretch of the imagination. And I'll close with this. If we can't trust you around YouTube's privacy abuse system, and you will abuse YouTube's flagging system to your own goals, to shut someone down and to delete their content because you personally feel like it, even though there has been no violation of law, then how the hell do you expect us to trust you with the trademark for Creepypasta and to never enforce it on anybody and to never do anything that, you know, people don't like with it? We can't even trust you with YouTube's, you know, abuse system. And I take that personally because, as I said, I could lose my channels if people flag bullshit. Because YouTube, all it takes is someone at YouTube not paying attention, not caring about their job, and just putting through, yeah, fine, whatever, closed. Delete it, whatever. That's all it takes for me to lose something because you got pissy about it. And you're sitting there expecting, you know, everybody to just take your word for the fact that you won't ever do anything at all to enforce this trademark you purchased when you will actually abuse systems toward your own end. I don't know. I'm sure you're a nice guy. Everybody makes mistakes. I said in the videos that you flagged to be removed, I said people make mistakes all the time, people make bad decisions, and that I didn't think you were a bad person. I do think you're dishonest. I do think you're lying. That is my personal point of view. I look forward to the flag.